Hey everybody, it's Dave, and we have an update on the Baldoni versus Lively soap opera that'll never end. We have a response from Justin Baldoni, and he calls, this is in response to the New York Times saying that he's being overly intrusive. He says, no, we're not overly intrusive. Blake Lively's side, they're the ones that want all the overly intrusive stuff. So I'll share some of the dunking that went on from his response. It's not that sexy, but it's an appetizer. And then also, very interesting, save the date. How about this? This is a different court document here. We have Blake Lively v. Wayfair, and then we have Wayfair v. Blake Lively. They're both plaintiffs and they're both defendants because they're both firing quivers at each other. In the United States District Court, Southern District, the court will hold a video conference via Microsoft Teams on the motion for a protective order. By the way, how these court systems are so old. The fact that they use Microsoft Teams, you know what I mean? I'm not saying they should be FaceTiming each other. It just feels so archaic. Anyhow, March 6th, Thursday, 2 days, 48 hours from now, 10 a.m. I'm guessing East Coast time. So your boy's going to get up a little early. Now, we won't be allowed to watch the video conference, but we will live stream this. The parties shall be provided instructions for hearing access via email. The court will post an audio-only dial-in number on the docket for the public and press to access the hearing. So ordered. All right, folks. Well, I don't even know if it's going to be interesting, but you'll be here with me. Double check, make sure you're subscribed, turn the alert bell on. That's 10 a.m. on Thursday, and we'll be live streaming it. So we'll have to, this is just, they're going to be there on Zoom, but who knows what'll be said. Will we get some sassy quips from old Brian Friedman? We'll have to see. So here's the update. This is Lively v. Wayfair. Oh, this is Lively Wayfair. I thought this was New York Times. So this is Wayfair, Justin Baldoni's response to the latest motions, the motions in the oceans. Dear Judge, as counsel for Wayfair, Justin Baldoni, Jamie Heath, Steve Sarowitz, it ends with us, Melissa Nathan, the agency group, Jennifer Abel, collectively the Wayfair parties. We object to the New York Times company's request for an order pursuant to Federal Rule of Civil Procedure, staying discovery as to the Times pending a determination of its motion to dismiss the Wayfair party's amended complaint. So this is their response to the New York Times saying, we're trying to get out of this, if you don't mind. And they're saying, no, not yet. Pursuant to Rule 26C, the court has discretion to issue a protective order on matters related to discovery upon a showing of good cause. Then they cite the court case. The burden of showing good cause for the issuance of a protective order falls on the party seeking the order. Republic of Turkey v. Christie's. To establish good cause under Rule 26C, courts require a particular and specific demonstration of fact as distinguished from stereotyped and conclusory statements. Discovery should not be routinely stayed simply on the basis that a motion to dismiss has been filed. A court determining whether to grant a stay of discovery pending a motion must look at the particular circumstances and postures of each case. Whenever anyone says particular, I think of Liam Neeson in Taken. You need a particular set of skills, and we have that, and it's called reading court documents. Courts should consider multiple factors, including the breadth of discovery sought, the burden of responding to it, the prejudice that would result to the party opposing the stay, and the strength of the pending motion forming the basis of the request for stay. None of these factors weigh in favor of staying discovery as to the Times. First, oh boy, you know it's never good when there's a first, second, and third. You ever get in a fight with your lady and they're like, well, 3 parts, and you're like, oh boy, and then they're like, first, you should have put the toilet seat down. You gaslighted me when you said you did. Okay. And third, seventh, okay. First, the Times has not demonstrated that the discovery sought from it will be voluminous or burdensome. The Times' allegation that discovery in this case is likely to be far-reaching, expensive, and wrought with complications is based upon pure speculation. Indeed, no discovery demands have even been served upon the Times by and party to this action. So the Times is saying, look, it's going to be a whole lot. And they're saying, hey, you didn't even let us do a show. Maybe we just wanted to see a little bit. When in fact, they're probably right. It probably would be expensive and a lot. But hey, that's what you get when you write an article with half the story. Furthermore, to the extent that the Times is concerned, and here we get, this is where we start dunking. Whenever someone says furthermore, they're about to dunk. You know what I mean? Furthermore, there was a hair in the lasagna. So I will be taking action. Secondly, My Yelp page has a big star rating, which means, okay, you ever get hair in your food? I'm taking it to Yelp. Furthermore, white women love Yelp. Oh my gosh. My wife won't go to a hot dog stand without Yelping at first. It's like, just roll the dice. It's a hot dog. Indeed, no discovery demands have ever been served upon the Times by any party to this action. Furthermore, to the extent that the Times is concerned about requests for call logs and other extensive discovery, we note that such overly intrusive discovery was sought by the lively parties, not the Wayfair parties. Whoever smelt it dealt it. And this court, in granting the Wayfair parties' recent motion to quash certain subpoenas, advised the lively parties on how to appropriately narrow their discovery request. That's such a dunk on the lively parties. The court basically court-splained to them how to do their job. In any event, given that Miss Lively alleges that the purported negative media campaign did not begin until approximately August of 2024, coupled with the fact that the Times article concerning the alleged smear campaign was published in December of 2024, the relevant period for any discovery sought from the Times is extremely narrow, thereby undermining any claim of burdensome. The Times' argument that it should not be compelled to litigate complicated issues related to discovery is unavailing. If that was the standard, then virtually no discovery would proceed in any case with a pending motion to dismiss. See Brower versus Egan-Jones Ratings Co. Denying stay of discovery pending motion to dismiss because some burden exists in all discovery. Moreover, even if the Wayfair party's claims against the Times are dismissed, which is unlikely, the Times will remain a critical percipient witness as it relates to the other claims herein and will, accordingly, remain subject to similar discovery obligations as a non-party. Denying stay of discovery because it is inevitable that some discovery may be obtained from defendant regardless of the outcome of her motion. Denying stay of discovery because burdens therefore are unlikely to change substantially regardless of how the motions to dismiss are decided, given that mouvants will remain key witnesses even if the claims against them are dismissed. So I'm not smart with law. I've only covered a few different cases, but I have to say, this is kind of like a nice crash course in seeing legal dunking happening. They're very careful to not completely throw the other team under the bus because they'll have to see them at, company barbecues and whatnot. That old company barbecue you go to, I don't think Baldoni and Lively will attend. If so, Baldoni, can you imagine he goes to the company barbecue and it's in the basement and he's like, golly, the basement again? Let's get Baldoni a house with no basements. How about that? But yeah, I'm an idiot. So when I read this, I'm reading it from my own idiot angle, and I'm trying to sort of teach myself and read it slowly. Because if you read this too fast, it makes no sense whatsoever. But as I've read so far, this is Justin Baldoni's side saying, hey, we just need a very limited, give us August of 2024 onward. That's all we need. Now, if I was the judge, I would say, you know what? Just for fun, let's go back to May. Let's just see if there's something before. You know what? Let's go back another year just to make sure there's nothing there. Second, the Times has failed to establish that, because could you imagine if it's found out that the Times was communicating with Blake Lively from the beginning of the 17 things she needed to do? I don't think that was the case, but whoo boy. Second, the Times has failed to establish that the Wayfair parties will not be unfairly prejudiced by the request for a stay. While the Times contends that the requested stay is for a short period of time, the Times cannot predict when the court will decide the motion to dismiss. Most likely, a stay of discovery as to the Times will significantly disrupt the deadline set forth in the case management plan and scheduling order. As it stands, fact discovery is scheduled to be completed by August 15th, less than 6 months from the date of this letter. Even assuming the Wayfair parties are not unfairly prejudiced by a stay, that alone is insufficient to stay discovery given the other factors weighing against a stay. Third, the Times has not made a strong showing that the Wayfair parties' claims are unmeritorious. As part of the merits analysis, courts have also considered whether a pending motion to dismiss will dispose of the whole action. On the first factor, so then they go in. Additionally, it's almost over, folks. I'm almost done. Additionally, when an assessment of the merits of a plaintiff's claims involved a fact-intensive analysis, such as choice of law assessment, Courts have declined to conclude that a plaintiff's claims are unmeritorious. Ms. Lively's amended complaint contends that California law applies to her claims against the Wayfair parties. In its motion to dismiss, the Times contends that New York law applies to the claims against it and concedes that the laws of California and New York conflict for some of its claims. Given the choice of law analysis the court must undertake to decide the dismissal motion, the court should decline to stay discovery for this reason alone. Even if New York law were determined to apply to the defamation claim, the court cannot determine as a matter of law that the state's fair report privilege applies because it is for the jury to decide if the context in which the statements are made makes it impossible for the ordinary viewer or reader to determine whether the publication was reported on a judicial proceeding. Although the Times argues that its article merely reports Blake Lively's California Civil Rights Department complaint against Justin Baldoni and others, and thus purportedly is absolutely protected under New York's fair report privilege, the Times dismissal motion acknowledges that the article went beyond reporting. Here, the article lays out in great detail the factual basis for its conclusion that plaintiffs engaged in a smear campaign against Lively. The amended complaint thoroughly alleges why the article is not a substantially accurate summary of the administrative complaint. This is pretty interesting, right? So what they're saying is you didn't just report the news, you also gave your opinion. And your opinion was that it was a smear campaign. And moreover, I'm trying to use smart words here. Next time I'm in an argument with the wife. Moreover, I did put the toilet seat down. The wind brought it back up. They presented their opinion as fact, right? By saying it was a smear campaign, they're not saying it's our opinion it's a smear campaign. They're saying plaintiff engaged in a smear campaign. For good measure, the Wayfair parties intend to seek leave to amend their pleadings to remedy any defects therein that might otherwise support the Times' motion to dismiss. We respectfully request that the court deny the Times' motion for a stay of discovery. At a minimum, moreover, document discovery with the Times should proceed, and the court should stay that party's deposition, only pending its motion to dismiss. Signed, Brian Friedman, power attorney, and all the other attorneys. Boy, there's a lot of attorneys there. It's getting expensive. So Justin essentially says the New York Times lied, right? And therefore, they're not just presenting the facts. And because of that, they're not entitled to whatever the law is that entitles First Amendment speech, right? Isn't that to make that argument right? Who knows? I don't know. I'm just reading it. Prepare for Thursday morning. Whatever meetings you had at 10 a.m. East Coast time, cancel them. Just move them. We're going to need you. Let me get my gavel. I need every single one of you guys to be ready at 10 a.m. Thursday. In fact, maybe 9:45 a.m. So put your boss on the line. Call your doctors. Push that surgery. Whatever mortgage house you were closing on, get rid of it. You may have been going to divorce court. You can do it later. We need you on Thursday. We'll see you then. More content before then, including the next story, which is Brandon Sklenar now Team Justin Baldoni? Clues point to saying yes. We'll have that for you next.